Hello, and welcome to another episode of Cause for Action. I am Scevole de Cazotte, Senior Vice President at the U.S. Chamber of Commerce Institute for Legal Reform. As part of its Green Deal climate policy, the European Commission has recently proposed a series of new environmental, social, and governance, or ESG, legislative initiatives to impose extensive new financial reporting and compliance obligations on companies. We will discuss today one of these legislative initiatives, the draft EU Directive on Corporate Sustainability Due Diligence, which was issued back in February of this year. The proposed EU Directive would create new regulatory and liability burdens for companies operating in and outside the EU. It raises important questions, some of which we will address today. Here to discuss the directive with me today is Ken Daly, Managing Partner at Sidley Austin's Brussels office and an expert in EU competition and regulatory law. Thanks for joining us today, Ken.
Thanks, Will. Thanks for having me.
Let's start with the basics on what exactly is the goal of the Corporate Sustainability Due Diligence Directive.
Sure. Well, so the EU has a concern in relation to human rights and environmental sustainability, like we all do. It has a specific concern that the way businesses are operating, both in the EU and globally, is having an impact. Now, the EU clearly has its own ability to constrain what businesses are actually doing in Europe. This directive, though, tries to do something quite novel, which is to put some new rules in place in relation to what businesses can do in Europe, but also put requirements on them in relation to everything they do also outside of Europe with regard to sustainability and human rights. Specifically, what they're trying to do is make sure that the entire supply chain of companies operating in Europe respects norms that the EU is going to set with regard to human rights and environmental sustainability. So it's quite novel, mainly because of its global reach and its extraterritorial scope, and its plan is very plainly to make sure that there's a way to regulate and punish companies where they have not taken proper account of the global impact of their supply chains. So that's in its biggest picture what the goals of the directive are.
So this is quite broad, in fact, and I imagine that European companies are very concerned by this. But why should American companies care?
Well, so the plan for the directive is, as I mentioned, it's first of all not only European companies that are going to get caught up in this. The directive is going to apply to, first of all, EU companies, that is companies that are based in the EU when they have 150 million euros of sales and 500 employees. So it is, in the first instance, focusing on large EU companies, but it also applies to non-EU companies. That is, say, for example, a US company where that company has 150 million sales in the EU. So the EU's own estimation is that this legislation is likely to capture about 13,000 EU companies, but as many as 4,000 non-EU companies, and those, of course, are likely to be the largest US businesses that have any kind of material operations or sales within the EU. So the fact that a company might be based in the US, might be mainly focused on the US, might have operations, all over the world and only incidentally in the EU, will not be enough to get you out of the application of this directive. So as we've seen with some other European items of legislation, the goal here is, the EU wants to, in a sense, direct operations no matter where they are in the world.
Very interesting. It appears that the directive proposes that companies could be held liable for both human rights and environmental harms. Could you expand on this? And in short, what sort of harms will companies be liable for?
Sure. So the scheme of the directive is that it imposes duties on companies to first identify potential adverse human rights or environmental impacts within its own operations, within its own subsidiaries, but also all the way down its value chain, wherever that value chain may be in the world. And that is both its direct and indirect value chain. So just to clarify, we're not only talking about, let's say we have a large manufacturing company. It has its own subsidiaries. Let's say it has a manufacturing subsidiary in Asia. If that manufacturing subsidiary in Asia subcontracts to an external third party that has nothing to do with the corporate group of the entity, it's still included in this. So the idea is that the liability will exist for everything all the way down the chain. So this directive will create responsibilities on the company caught by it to identify and try to mitigate and prevent environmental and human rights harms all the way down the chain. So in relation to there are different obligations in relation to human rights on the one hand and environmental on the other. The truth is, it's a little bit unclear exactly what the human rights, the standards will be, and a little bit unclear what the environmental standards will be. It's clear what the goals are, and I think everyone would agree that where there's a material impact on human rights or material impact on the environment, then clearly there's a problem. So that's not really the issue. The issue is that the way the EU proposes to define what the problem is simply by reference to international conventions that are really intergovernmental international conventions. So let me give you some examples. On the human rights side, for example, the directive says that companies will be liable for failing to prevent harms arising from breaches of the Universal Declaration on Human Rights, or the International Covenant on Civil and Political Rights, or the UN Convention on the Rights of the Child. Those are just some examples. There's a long list of sort of international conventions, international agreements, sometimes UN-backed, sometimes intergovernmental. And so, as I say, the goal, maybe these human rights violations are in that category of things that you know them when you see them, to some extent. But when you're trying to create a legal liability test, it's quite unsatisfactory for the rights to be defined only by reference to these, kind of high-level framework type conventions that do things like, make these kind of general statements, such as, the right to the right to life and security shall be protected. The right to property shall be protected. The right not to have your freedom of thought or conscience or religion interfered with shall be protected. That's the kind of nature of the international conventions that we're talking about. So the EU says any harm arising from any breaches of any of those kind of high-level principles can lead to direct liability for the companies caught up in the directive. It's exactly the same on the environmental side, where there are references, for example, to the need for companies to have policies to make sure that their strategy is consistent with the Paris Climate Accord and the overall goal of achieving 1.5 degrees centigrade, no more than 1.5 degrees centigrade in terms of global warming. So, but it's drawing from that very high level intergovernmental objective a direct line of liability and responsibility for individual companies for, if you like, failing to prevent or for failing in some way to identify and prevent harms arising in those categories. So it identifies harm to soil, to water, to biodiversity, etc. And again, all extremely worthwhile and noble goals, and nobody would, I think, object to those goals. But I think the difficulty with this directive is it's a technical one. It's how does a company comply with something like that? How do you know when you've done enough to prevent, when you've done enough as an individual company to ensure that your company has done enough to support the Paris climate goals, for example? Whether you support the goals or not is not at all the point. It's just a question of the technical certainty. It's very difficult for companies to achieve that on either of those human rights or sustainability sides.
Yeah, I was going to say, in practice, it seems to me that companies will have to really figure out how to report and comply with this directive.
Yeah. So the system of it, we should probably talk a little bit about the enforcement system, because that's obviously when this is really going to bite. There are kind of three categories in which this is going to be enforced. First, there's going to be regulatory supervision. So each European member state, each EU member state will be required to set up a regulatory body that will have an ability to impose fines and rules on companies. According to the directive, those fines, there's no limit in the directive on what those fines might be. So in theory, they're unlimited. That will be up to each individual member country to determine what the maximum fine will be. So there's that. There's regulatory supervision. Second, there's a category of directors' duties, which addresses things that directors themselves personally are required to take into account when they're setting the strategy for individual companies. One of the, I mentioned the Paris climate goals. One of the elements of the directive is that in setting directors' remuneration, it's necessary to take into account whether the director has individually done enough to support the Paris climate goals. So there's a category of directors' duties which is reasonably far-reaching. But I think the one that is perhaps potentially of biggest significance is that there's a system of civil liability foreseen. In some ways, the EU's goal is that this will become self-enforcing, self-policing by creating a compensation sort of system around it. Specifically, the idea the EU has is that it will be possible for individuals to sue companies where a harm has arisen from a breach of any of the limitations that I've outlined. Now, there are all kinds of questions about how that's going to work and what it's going to look like. But in principle, the idea is that individuals will be able to take actions defined by national law to sue companies and to receive compensation. And that will, in the EU's mind, deter companies sufficiently or encourage companies sufficiently to comply with these goals. Like I mentioned, there's a material gap there between the risk of having to pay compensation for breaching a rule and even knowing what the rule is. So there seems to me to be a lot of ground to make up in the middle there, and a lot of potential uncertainty and danger for companies in that circumstance.
Do we have Do we have a sense of where those cases could be litigated?
It's very difficult to tell, and here's one of the reasons why. The directive doesn't give any guidance at all on that question. It's left simply to EU law, to pre-existing EU law to try to figure out. And the answer in EU law to that question is very difficult to determine. So there will be, in each and every member state, there will be a parallel civil enforcement system set up. There's no kind of federal court that will be able to determine these cases. There's no single EU court that will naturally have jurisdiction over enforcing this. So there's no intuitive place that a plaintiff wanting to sue a company would go to in order to initiate their action. Instead, they'd have to figure out the usual things. Where is the defendant based? Where are the victims based? Where is the harm arisen? Where is what is the location of the law that applies to the issue complained of, etc. But it's clear that this directive tries to anchor enforcement in the European member state courts. So how exactly and which of the courts will be the relevant one remains to be seen, but the goal is certainly that that courts within the EU will have that jurisdiction. So it won't be enough to say, hey, this all happened in Asia. This has nothing to do with the European courts. I think in that situation, the goals that the Commission has set for the directive would not have been met.
Very interesting. And while the EU's goal is to anchor enforcement within the EU, we can imagine that some litigation could occur outside of the EU.
Oh, for sure. There's, along with the obligations that the directive imposes, will be all kinds of obligations for companies to state and report on what they've done in order to identify problems with their supply chain. What due diligence steps have they taken in order to mitigate those? Where have they found a problem? Where have they eliminated a problem, etc. So it depends on a degree of transparency and reporting about what companies are doing. Now, inevitably, if a company, is required to issue a report about something, then that could, of course, trigger litigation in many jurisdictions around the world, in the US and others. Equally, the additional, regulation and the regulatory architectures that will be set up in each and every member state. It's unclear at this stage what kind of, how public or not their roles will be, and what kind of disclosures companies will need to make about what they do and how they do it. Now, if something is wrong, then I don't think anyone is complaining about the the need to make some kind of a disclosure. But as you know well, there's a lot between that. There's a lot of potentially somewhat opportunistic plaintiffs can make a lot of hay out of disclosures. Even the existence of an inquiry into something can on its own trigger class actions, or can have material share price consequences and other things, even if there's nothing really much underneath it. So again, it's an area of pretty material uncertainty. I should add one important thing about the civil liability risk, which is that there is, I think, you could say one of the best bits of the directive is that it does create a defense, a ready-made defense for companies when they're facing a civil suit for having breached some of these obligations. In particular, when the breach arises from a third party not within their group, outside of their real jurisdiction. It does say that it will be a good defense to show that companies have made proper efforts to set up a due diligence system to try to secure the contractual guarantees, appropriate contractual guarantees from third parties that are assisting in the supply chain. So, put simply, if a company can show that it's done all that it could do in order to get proper promises from third-party suppliers that they wouldn't, breach these norms, then a company might be insulated from liability. So that's good in concept, I guess. Though, two things about it. One is that having a simple contractual exclusion. If that's all it takes in order to avoid liability, then you could ask, whether the EU's goals are going to be met. And the second one is just as a practical matter, what is an adequate contractual promise? What is an appropriate amount of due diligence? How are you really supposed to investigate whether a non-owned third-party supplier, really is respecting human rights and environmental norms? It's very difficult. It's very difficult now, and saying that you must do it will, I'm sure, cause companies to increase their efforts, but it doesn't make the challenge any more easy to overcome.
Yes, I agree that compliance defense is an important element of this proposal, and but there's a lot to think about, and I guess a lot to engage on in Brussels while this rule is being debated in the European Parliament and in the Council. So I encourage you all to engage. But now it's time to conclude this episode. It was very interesting. Thank you very much, Ken. We'll see you next time.